Peace to the family, peace to the family. It is me, Brother DSP, your friendly neighborhood media personality, and you're now tapped in to another installment of Onslaught Multimedia. I truly appreciate you guys pulling up. Today's content, we'll be discussing what's going on with the Legio. It looks like there's going to be a speedy trial in this moment. And I know some of y'all are wondering why I have been posting Eligio, his angels and all that. And it's like, we already seen those videos, this, that, and the third. It's just a refresher for those who haven't peeped my content before or haven't been in tune with me before. So I just put those out there. But with this newer content, we got to discuss Eligio possibly not waiting 2 months, and they'll probably get it in within the next 2 months. Pack him up and get him out of here because the evidence is overwhelming. So shout out to Simply Anna. This is where I got the clips that I'm about to play from. So huge shout out to her. She's putting in the work. Also, shout out to Sasha for God, and shout out to the T. They've been putting in the work for this whole Eligio situation. And shout out to them. You'll definitely see Simply Anna's link in the description box. I have to make sure I give her props and you guys see what she's been up to, peep the work that she's been doing. So, hey, let's get into this video. I will not be coming back, so please be sure to like the video, leave a comment, subscribe to the channel, click the notification bell, then select all to get every single notification. Enjoy the video. Peace.
This is just a general discovery request. In Georgia, if you want to participate in the reciprocal discovery provisions, that is where the state has to give you certain things beyond just a list of witnesses, but instead give you statements of witnesses, actual scientific reports, and things of that nature, you have to elect to proceed under the discovery statute. The defense is then required to produce certain things to the state. It's a reciprocal discovery statute. That's the only way you can get discovery in Georgia. So it's an opt-in state. So it appears that they have opted in. In addition, they have they're objecting to the state introducing any, certified crime lab reports or anything, and which the law specifies can come in without a witness testifying. They're objecting to that, and that they want the state to bring those witnesses in. And then finally, they are objecting to, I'm looking for the other piece here. There was another provision. The state is also being told to produce any exculpatory information present at this hearing or that hearing. And the defense is objecting to the witnesses being allowed to sit in those hearings because they might hear evidence or the like. Whereas when you're during a trial, you can ask that the witnesses be sequestered by invoking the rule of sequestration. And if you do that, then the witnesses can't be in court when testimony is happening, and they can't discuss their testimony amongst each other. They are effectively sequestered. So that's what's happening here. So they're not waiving discovery. They're demanding discovery in this situation. It's pretty standard. Also, they are not requesting a statutory speedy trial because they didn't plead the language for a statutory speedy trial, which is under Georgia law. If you demand it, you have to be tried in the term of court or the next succeeding term, depending on the nature of the offense. You can also get another term. But the bottom line is, if you specifically invoke the state statutory speedy trial statute, or you plead the language that says that the defendant shall be tried or discharged, you got to put that kind of language that says you are putting them on notice of the state statutory speedy trial demand. Then if you're not tried, you will win your case by default because you will be acquitted by operation of law. But this only invokes the Sixth Amendment here, and just simply says they demand a speedy and public trial pursuant to the Sixth Amendment of the United States Constitution, and not the state statutory speedy trial. So it would only be analyzed under the Sixth Amendment standard, which is far more lenient. toward this state. But it's a good way to preserve those rights in case a case lingers on and the court says, well, did you demand a trial? And you can say, yeah, I demanded a trial. And I said I wanted it to be speedy under the Sixth Amendment. And then this can have implications, down the line if this case lingers on for a few years.